Dream of watching Karl Rove frog marched out of the White House in handcuffs. He is long since gone, but a new dream has been born tonight. What about a turd blossom perp walk out the front door of Fix News down the street? Our third story in the countdown, the House Judiciary Committee today issuing a subpoena ordering the former presidential advisor to face questions about the White House's role in the firing of those 9 U.S. attorneys, as well as the dubious prosecution of former Governor Don Siegelman of Alabama, a Democrat. Last week, just off the House floor, a reporter for Politico.com having overheard Judiciary Chair John Conyers when he said, "We're closing in on Rove. Someone's got to kick his bleep." Asked a few minutes later for a more official explanation, Congressman Conyers elaborating, saying that if Rove does not appear before his committee, quote, "We'll do what any self-respecting committee would do. We'd hold him in contempt, either that or go and have him arrested." Let's turn now to George Washington University law professor Jonathan Turley. John, good evening.
Hi, Keith.
Until last week, Karl Rove's lawyer, Robert Luskin, said, "I do not understand why the committee is threatening a subpoena to Mr. Rove." Are the legal complexities here really that hard to understand?
Well, I'll take a stab in the dark. It probably has something to do with the fact that his client won't answer proper questions from a congressional committee with oversight responsibilities, but that's just a shot in the dark. The other possibility would be that his client is in flagrant open contempt of Congress by not showing up if he does refuse the subpoena.
The term bleep kicking, obviously that's a legal term, but let's just assume that he does not intend to show up, or he's already said he's not going to go voluntarily. And they've ignored subpoenas left and right for the length of this administration. Does John Conyers have some sort of mechanism to have Boss Rove arrested, or would he have to involve the Justice Department, presuming there's still a Justice Department?
Well, the traditional way is for him to refer the matter after a vote of his colleagues to the Justice Department. But Attorney General McCasey has already said that he is not going to allow his prosecutors to present these cases to a grand jury for indictment. It's an extraordinary act because Congress does have what's called inherent authority or inherent contempt authority. When this republic was founded, Congress would indeed actually arrest people, drag them into the House or Senate, try them, and order them incarcerated. They gave up that power with a basic understanding that the Justice Department would serve as their lawyers. But what McCasey's saying is he won't allow a grand jury or a court to see the basis of this contempt. So some have suggested that Congress should say, deal's off. We'll go back to using inherent contempt if you're going to rig the system, if you're not going to let a grand jury see the evidence.
If he doesn't show up on July 10th when this is answerable, and he's not cooperated with the committee, is there a statute of limitations on the contempt of Congress? Could this be something that could be dealt with by the next Attorney General on the 21st of January of 2009?
Well, the way that this is usually handled is that the contempt of Congress extends through that Congress. And then when the new Congress comes in, they can reissue the subpoena. But what the White House is counting on here is not the Constitution, but the calendar. You know, the White House has engaged in a wild extension of executive privilege. I don't know anyone who believes that the president can deny the participation of all these individuals before Congress. Congress clearly has the right to ask these questions. So they're not going to win in court. They're just hoping to outlast Congress.
You've invoked them not by name. The names are Harriet Miers, John Bolton, now possibly Karl Rove, not even bothering to show up to claim executive privilege. This is now almost institutionalized. What does Congress do about this, short of literally rearming the sergeant-at-arms?
Well, that's the problem, Keith, is that the president has once again forced a constitutional crisis. He's basically telling Congress that even if I did politicize the Justice Department, even if there's crimes here, I can tell people just not to give you evidence. And we have now this long list of people that are refusing to testify upon orders of the president. Congress has to do something about that. If it's not going to become a virtual governmental eunuch, it has to do something when people look at the Congress straight in the eye and say, I just don't give a darn whether you're subpoenaing me or not. I'm just not going to show up. So it's a direct challenge to the legislative branch. And I must say that John Conyers is not the guy to mess with. I think his first statement was probably closer to his intent. And I think we're all going to watch to see whether Chairman Conyers is going to go to the mat. But in that fight, I'd have to bet on John Conyers.
One correction and then one last question. I said John Bolton. Of course, it was Josh Bolton, the chief of staff. Conceivably, is the Attorney General in contempt of Congress for saying that? Is Mr. Mukasey somehow citable?
Well, I think that Mukasey has proven to be a perfect nightmare. And the question is, once again, to the Democrats who saved him, Senator Schumer and Feinstein, when they protected him from answering the torture question, I think that this is a terrible legacy that they have brought. He is positively fighting Congress tooth and nail, getting any information at all on this, torture, and other subjects.
And unlike his predecessor, he appears to have actually gone to law school. Constitutional law professor Jonathan Turley. As always, John, thanks for your time.
Thank you, Keith.